The United States Supreme Court in Aaron B. Cooley versus the Board of Wardens of the Port of Philadelphia considered the constitutionality of a state law regulating ship pilots under the Commerce Clause. An 1803 Pennsylvania law required ships entering or leaving state ports to hire local pilots. Ship owners who didn't hire local pilots were required to pay the Board of Wardens of the Port of Pennsylvania a fee equal to half the cost of hiring a pilot. This half-pilotage fee funded an aid society for elderly pilots and their widows and orphans. Aaron Cooley owned 2 ships that sailed from Philadelphia without local pilots. Cooley didn't pay the half-pilotage fees, and the Board of Wardens sued him for the fees in Pennsylvania State Court. Over Cooley's challenges, both the Pennsylvania Court of Common Pleas and the Supreme Court of Pennsylvania concluded that the law requiring the half-pilotage fee was constitutional. The United States Supreme Court granted Cooley's petition for a writ of error and accepted the case to determine whether and under what circumstances a state law might regulate matters that touch upon interstate commerce. Justice Benjamin Curtis, writing for the court, concluded that the Pennsylvania law was constitutional. The court held that the law didn't violate the Commerce Clause, which reserved to Congress the power to regulate commerce among the several states. State regulation of local matters that don't require a uniform national regulatory scheme can exist alongside congressional legislation enacted under the Commerce Power, so long as the state law doesn't conflict with federal law. In this case, the Pennsylvania pilot law regulated commerce. Congress's Commerce Power included the power to regulate navigation, which in turn encompassed the regulation of pilots. And Congress had exercised its power to regulate pilots. A 1789 federal law required states to continue regulating pilots while Congress considered the matter further. But the Pennsylvania law wasn't enacted until 1803, so the Supreme Court couldn't say that Congress had adopted the Pennsylvania law as its own in its 1789 enactment. In other words, the Commerce Clause didn't divest states of all power to regulate pilots. And although Congress had legislated on the subject, its 1789 law showed its intention to leave the matter to the states. The regulation of pilots didn't require a uniform national regulatory system. Rather, local port characteristics and the nature of piloting practice required local, individualized regulatory schemes. Those were best devised by the states. The 1789 federal law recognized these realities as Congress concluded that state laws should continue to govern. Thus, the Supreme Court affirmed the judgment of the Supreme Court of Pennsylvania that the pilotage fee law was constitutional. Justice Daniel, in his concurrence, concluded that the states had inherent power to regulate pilots. States had done so since before the United States' independence, and the power was an appropriate and necessary one to be exercised at the state level. Regulating pilots at the state level didn't necessarily conflict with Congress's right under the Commerce Clause power to enact commercial regulations. Justice McLean dissented. In his view, Congress's 1789 law, which adopted the existing state laws on pilots as Congress's own until it could act further, signaled Congress's intent to claim the entire field. Therefore, later enacted state laws regulating pilots, including the Pennsylvania statute here, were unconstitutional. Cooley is important because it established a case-by-case, subject-specific approach for determining whether a state law conflicted with Congress's commerce powers. In general, local matters that might be expected to vary from state to state required state legislation. Meanwhile, commerce requiring a uniform regulatory system fell within Congress's purview.